Estate planning isn't just for the ultra-wealthy or the very old, but the very first hurdle is usually procrastination. Let's talk about that today with a special guest on Millstone River Live. Welcome to another episode of Millstone River Live, a podcast brought to you by Millstone River Wealth Management. I'm pleased to introduce my guest for today's conversation. Anna Pelligra is a trust and estates attorney based in Manasquan, New Jersey. Anna began her legal career drafting estate planning documents including wills, living wills, healthcare directives, powers of attorney, and trusts. Recognizing that estate planning can be intricate and emotional, she brings compassion along with her understanding of the law to each client situation. Additional information about Anna and her firm can be found online at acp-law.com, or you can reach her by phone at 732-288-6162. First, I want to thank you, Anna, for joining us on Millstone River Live. This is a topic that I think a lot of people struggle with, but everyone needs to entertain at some point, and maybe more than at one point. I'd like to start with you by talking about what I perceive to be one of the biggest hurdles, and that is procrastination. I think many of our clients and even some people listening to this podcast will assume estate planning is really for ultra-wealthy or elderly. And we talk to people about different lifetime milestones that they might encounter in which they should talk to someone like yourself about estate planning. Maybe you could just take a moment on, what are those life milestones and how do we overcome this procrastination issue?
Of course. I always find that the hardest part of starting this process is sitting down for the initial meeting. A lot of people come to me, even in, 85 plus, and they'll say, I'm sorry, I never got this done. And I always say, it's okay. You're still here with us. You're still mentally capable. Let's get this plan done. Better late than never. So a lot of the life milestones that bring people into the conversation is, getting married, potentially purchasing a house, having a child. Having a child, I find, is really the biggest one because you have to talk about guardianship. And people really worry, oh, no, I'm going to a wedding without my child. What happens if, I get in a car accident or something? And then the other thing that I find that a lot of people come into my office for is there's a death in the family, and they see how, mom passed away and she didn't have anything organized, and how hard it was for them to deal with and get through the process. So that also brings a lot of people in just saying, I don't want to put my kids in the situation that I have been in. But procrastination is, key. If one of those large life events don't happen, that's when you get into having, I don't want to talk about death. I don't want to start this conversation. But I always say, life and death is really the only, guarantees of life. So you might as well plan for it. Obviously, I'm in this career, so it's a little easier said than done, but it's hard to get over that hurdle.
Yeah, so if we all know we're going to die at some point, then that's not the question. The question is, are we prepared and is our family prepared, right? And I think that's what you're speaking about. Yeah.
Exactly. And I also pulled a few statistics just for, to make people feel comfortable and relatable. 20 to 35% of Americans have a will. The other, 65 to 85% do not have a will. So the top reason the people that don't have a will is procrastination. So I don't want people to feel bad that, they haven't put their plan in place. Most people are in the same boat.
And I wasn't even aware of that stat until you just said it. So it sort of supports what I've thought often. I think I shared with you too that, we'll recommend to someone that they speak with an attorney about doing estate planning. And sometimes it never gets addressed. Sometimes it gets addressed months or years later. But I think what you said is key. The two things that you find over and again is one, someone saw someone else in the family who died unprepared for the legal and financial type considerations. And then the other is when you have a baby because now there's someone else who's dependent on you, right? And you're dependent on your good decision making.
Exactly.
Yeah. So that makes a lot of sense. Switching gears just a bit, we often hear the terms will and trust used interchangeably. Maybe you could kind of put it into plain English and explain the difference, And maybe even if you want to add a twist, talk about adding revocable trusts into that.
Sure, definitely. So the will is technically just the legal document that states how your assets should be distributed upon your death. Usually names fiduciary positions post-death, including guardian, executor, trustee, and you're really not putting this document into effect until you pass away. So you're really doing all of the hard work so that your fiduciaries can hit the ground running upon your passing. On the other end of that is the revocable trust. That's more of a living document, something that you fund during your lifetime to either avoid probate, or really, get your life organized more during your lifetime and funding it rather than waiting until death to get assets moved to help the beneficiaries. This is very state-by-state specific as to what works best for your actual scenario. There's, in our state in New Jersey, I wouldn't always recommend a revocable trust because probate avoidance isn't really something you have to worry about. But if they have a property in Florida or New York City, those probate processes are horrible and you want to avoid them at all costs due to delays, expenses. So it really is kind of client specific, but I always talk through both options with clients so that they understand the difference, because that's like a common, misconception and confusion when you see like internet articles or the people that talk about it on the news, and you have to have a revocable trust. It's very client by client specific.
And I think that helps. One other thing, you mentioned the word probate a couple of times, just to make sure everybody listening is, up to par with where we're talking today. Maybe you can put that term into plain English too.
Sure. Probate is going through the surrogate court in the county that the decedent lived in. They essentially have to make sure that the will is valid, make sure that asset information is provided, and it's almost like the court system kind of overlooking and monitoring your administration of the assets that the decedent held during a lifetime.
All right, good. And it's also good to know that that's one of the things about New Jersey that people don't complain about.
Correct.
We don't have many. So there's another misconception that I hear from people when we have conversations on this topic, and that is that estate planning is really about death. But I know from talking with you that that's not all it is. Maybe you can take a moment on some of the living aspects of estate planning.
Definitely. I actually have a lot of clients that come into me and say, I don't need an estate plan, I just need a will. When they say that to me, I say, well, estate planning is really the umbrella term for the documents that go into a plan, both living and post-death. So I always say that everyone should have at least 2 of the 3 main documents, and realistically, once you start to get assets, they should really have all 3 documents. I call them the big 3. That would be the last will and testament, so that's the death document, and then the 2 ancillary living documents, which is the financial power of attorney, and then the healthcare directive / living will. And these ancillary living documents, people don't think about or don't understand the importance. And I have a few real life examples that I could bring up to
Please.
Explain. Sure.
Yeah.
I actually had a client, 65 years old, was super stubborn, did not want to sign these documents. And usually when that happens, I'm like, oh no, something might happen to this person. Like, they're the ones that need it, kind of in that, later in life stage where, God forbid, something happens, you really need the documents to help you out there. He ends up having a stroke. He's in a medically induced coma for a month and a half. And because he did not execute the documents, his next of kin had to petition the court for guardianship. His only next of kin was his 88-year-old mother in a nursing home, couldn't drive, couldn't see. The poor woman, I felt so bad for her. If he had just signed these documents, she wouldn't have to go through the stress, expenses, and really, that's not something she wants to deal with when her son's in a coma and she can't speak to the doctors. So I always tell that story when I have clients come in, because they're like, oh, I don't need that. Like, I don't have dementia in the family. I'm going to be fine. When I bring that up, they're like, oh, I'd rather have this document in place. God forbid something like that happens. So it's good to bring real world examples and like seeing it firsthand to the client so that they can understand.
For sure. And I'm willing to bet money that guy you're talking about didn't wake up that day saying, today's the day I'm having a stroke. Let me get my life in order.
Correct.
Yeah.
Exactly.
And so because, there are things sometimes we can think about that are on their way. Often these sort of major life events come without any warning, and the lack of planning or the procrastination we spoke about a few minutes ago can come back to bite you later or hurt those around you which obviously you're not trying to hurt. You're trying to do just the opposite. That
Exactly.
makes sense, and it's good to keep in mind, I think. We talk about with people with certain accounts that they have with us about designating a beneficiary, for things like retirement accounts and life insurance policies. Maybe you can share a little bit more about why that's important or why that could be a big blind spot for so many people.
Sure. So as I stated, the estate planning umbrella, I also like to throw beneficiary designations under that umbrella. I think that is how you make the plan completely whole. And the reason I say that is because beneficiary designated assets actually do not run through probate. So they would go directly to the beneficiary, whoever is listed on that account. A lot of people just think, I have a will now, like all my assets, even my 401k, my life insurance policy, all of that is just going to run through the document I created. I always make sure to go through that with the clients. There's probate assets, non-probate assets. If you have life insurance, who are the updated beneficiaries? I have actually had clients that say, I think my dad is listed on the account. He died 10 years ago. And at that point, I always give them guidance. Here are the forms that you need to ask from the company. Here's who you should have listed on the account. So that's really part of the estate planning process, is to make sure that all of your assets are in line with your wishes.
That's good to know. And I think when we talk about beneficiaries, often a topic that comes up is terms like fair and equal. And many of our clients are concerned about making sure that the money that they leave, particularly to their kids, but not just to their kids, is either fair or equal if they have two or more, right? And sometimes I would say that folks struggle actually considering that and what's important based on that kid's needs or their life choices, let's say, and why it might be fair to do something that's not equal. You have any thoughts on that or examples to share?
Definitely. That's always a conversation that I bring up when there's multiple children. I always say equal shares to all the children. Do you want to do different percentages to the children? And then if they tell me different percentages, I say why. There has to be a reason behind it. You can't just say, well, that's my favorite child. You have to say, I've given, X amount of dollars to this child throughout their lifetime. I want to make it even upon passing. Or maybe the children have different financial situations. Maybe one is a single parent and, paying or living check to check. Some people have, a successful career. But whenever they do tell me that they want different percentages, I, be sure to have, correct notes in the file to, have, God forbid, something happens and they, want to sue the estate. But I also always recommend to the client to write a personal note that says, hey, honey, I love you this much. Like, it's not because of I like your brother more. I always try to add a personal note to it to, really have something for the client, to have something tangible to pass on. I also always say, have these conversations during lifetime. If you have adult children and you're going to give them different percentages, have these conversations so that they don't ruin the relationship post-death arguing over how come you got 75% and I only got 25%. I did a lot of litigation at my last firm with estate discrepancies and arguments, and a lot of it came from not having the conversations during life or not having a note from the decedent explaining their choices within the document.
Yeah, and I think, too, that comes into play often with adult children. How do you handle when somebody is worried about their minor age children, if they have one or more children that are under the age of majority? In New Jersey, 18 years old is when that changes. What do we do with younger children?
Definitely. I do recommend a lot of lifetime trust planning. So you can actually create trusts under your last will and testament or under your revocable trust, depending on what plan makes the most sense for you. I actually just made my parents update their documents because I was receiving everything outright. Granted, I'm an adult now, but I also would like to have protections, divorce, lawsuits, creditors come after me, especially owning a business now. So that's always a plus. But it's very important when you have minor children. If you have a 3, a 4, and a 5-year-old, there's a lot of years ahead of you that they will not be able to take over their own finances. So I always recommend these lifetime trusts, one for the protection aspect, but also for, guidance. So when you have a lifetime trust, you will have a trustee appointed as that trust. So it could be, Uncle Jimmy or someone that you trust in your close circle, and they will be there to say, no, son, you're not going to have a Ferrari. How about we buy you a Honda with this trust fund? So it's more just for guidance and making sure that the kids make the correct choices until they reach an age where they are comfortable with their finances. They understand, the makeup of the trust and the amount of assets that could potentially be in that trust.
So do you ever find an issue where people get stuck on who to name in that capacity?
Yes, a lot of the times. I always say, we can have a conversation. Who are your top 3 people? Some people say, I don't know. I don't have any of those people to name. And then that's when I would say, there are companies that serve as corporate trustees. But I at least recommend having co-trustees in place. So you have someone in your close circle that maybe is not great with finances, but has a great relationship with the kids. They don't have to do really the management of the trust, but they can at least be there to be kind of the intermediary, speaking with the child, trying to explain, this is the reason why we're doing X, Y, and Z. Kind of having someone in the close circle to bounce ideas off of and have like personal guidance added to the corporate trustee level.
So that's good to know. I think when I have these conversations with people, obviously I'm no lawyer and I don't pretend to be one. But people will talk about exactly how to handle that. And so it sounds like, I might have somebody that would otherwise be good, but isn't legally savvy or financially savvy. And maybe the corporate trustee that you're talking about could fill that void, especially in a co-trustee situation, right? Because what I talk about with people is you want someone who just loves your child and will understand what you would have done in a particular decision-making capacity or something, right? Isn't that more important maybe?
Definitely.
So you can put those two halves together, the more financially and legally savvy component with the person who you believe knows you and, cares about your kids.
Exactly.
Yeah, good to know. And that's something that you would recommend, I guess, during that planning process as well.
Yes, and I think having those conversations too, you have that human element where you can kind of see their body language, or you can see that they're a little bit hesitant on, person A, and maybe person B, they're like, oh yes, I think that they would be great. It just helps to like voice those opinions and kind of talk through it rather than just filling out a form, clicking submit, and thinking that, you made the right choice.
Yeah, and I think that's also one of those speed bumps early on in the process that derails this, right? That
100%.
Keeps people from moving forward. So I think it's good to kind of find the workaround because everything else is kind of held up until they do. I want to switch gears again with you, and that is to say asset protection. Sometimes people are worried about that beneficiary that they've named if they suspect maybe their marriage might be on the rocks. Or even if it's not on the rocks now, but they think, well, lots of people get divorced every year. What if that happens to my son or daughter? Maybe they get divorced. What happens then to the money that I've earned and that I left for them? Or if they get into some other trouble with a litigant or a creditor of some sort. How do we sort of protect the inheritance, if you will?
Definitely. So I did briefly discuss that with the lifetime trust planning, but to go in a little bit more in depth, I find that, say there's 3 adult children. They all love the spouses, the in-law spouses, but you never know. You'd rather keep the money within the family. The one nice thing about the lifetime trust that I create are that they would never go to someone other than your bloodline. So I add provisions in there that state if your child predeceases you or passes away when there's still assets in that trust, it would actually go directly to their children, also within trust, so a protected asset. Or if they do not have children, it would go back to your bloodline and go to your children or your other children's children. So I always try to keep that within the family. I also have a lot of people that say, oh, well, I feel bad about not including this in-law. And I always state that, their parents are probably doing the same planning to not include your child. So don't feel bad like you're just protecting your own family and your blood. So it's really not something to be worried about. This is a common, estate planning tactic that keeps money within the family. And it's also a benefit from a tax perspective as well to keep it within the bloodline, because then you don't have to worry about inheritance tax, talking about New Jersey specifically.
And I suspect that that's not the first consideration people come in to talk with you about is the inheritance tax at the state level,
Correct.
right? Yeah, they're thinking of those other things. So it's good that you can contribute to that, make it a more well-rounded kind of discussion. On that topic, we talk about blended families. Mm-hmm. And so there's divorces. Of course, second marriages or third marriages or beyond. There's stepchildren that get involved at that point very often. So, what's the danger of when somebody says, I just want a simple will or a sweetheart will or an I love you will? We've heard it called those things commonly. I just want to leave everything to my spouse and keep everything as easy as possible. What's the danger, I guess, in a blended family scenario?
Definitely. This is a common question that I get a lot. And I always bring up if I see that, kids have different last names. I'm like, are they all your children? Because you have to ask these hard questions and have these conversations to really get to, the main goal of the plan. One thing I always say is, what happens if client A passes away, leaving client B all of the money? Is client B going to get remarried? Would client B still honor your wishes to give assets to your children from your first marriage? I try to bring up these hard conversations, and sometimes I say, you don't have to make this decision now. Go home, talk about it. But please know that there are ways to guarantee that, your bloodline from your first marriage will still inherit, and there's really a guarantee to prepare for, rather than, just having hope that your surviving spouse will honor your wishes.
And obviously, these are not uncommon scenarios. I think they're probably more common than the the Norman Rockwell painting type scenario, and so that coupled with the simplicity of an easy will leads me to ask you about these online providers. Mm-hmm. So not to trash talk any company for what they do, but, we see these online services offering documents, $99 and you're done. I'm not sure if it's the price tag that appeals to people or the simplicity. Maybe it's a combination of the two. But what do you find is sort of the most expensive or devastating sort of mistake that people will make when using one of these do-it-yourself type online solutions?
Definitely. When I actually started this practice, I went online. They gave attorneys the option to kind of go through the system, see what it was about. And I really thought that I could answer every single question, like, do you want your kids to inherit in trust or outright? Who the trustee would be? But I don't think your average, person understands what a trustee means, or you can't really have that personal connection or conversation. Just like we discussed, you have 3 options for your trustee. Who do you think is the best option? Here you're just filling out a form thinking, okay, Uncle Jimmy's going to be the best. He's going to be fine. And then you realize that Uncle Jimmy is not good with finances, and, he isn't the correct person for that position. So I find that the human element is important in these discussions. And also just from purposes of, I guess, once you've completed the plan through the system, how do you sign the document? Not many people realize that you need to have a wet signature on all estate planning documents. You have to have 2 witnesses. You have to have a notary. And all of those people have to be in one room at the same time. So you can't really just go to a bank and say, okay, you need to notarize this, and then go back and have 2 witnesses. Technically, everyone has to be in the same room. Also, just witnesses in general, I find that people didn't know that the document had to be witnessed, or they created a will on ChatGPT and it didn't even provide for witnesses because it didn't know what state you were in. So all little things like that could add to huge issues on the probate side of things, and the court could say, well, yeah, it looks like the decedent signed this document, but how do you prove that that's their signature? And then that opens up really a can of worms where you might end up in court in front of a judge really deciding whether that will is valid or not.
And obviously, if somebody has any concern whatsoever, they want to make sure that their documents have the highest level of integrity so they can't be challenged easily. But I suspect there's a lot of people who don't know that there may be a future challenge. And I remember a lawyer that I've known for a long time used to always say, where there's a will, there's a relative, and
true.
Not always the one that you want, and that always stuck out in my head. But it seems to me that somebody might start with an online approach just to kind of get some of their thoughts on paper, mm-hmm. and then bring that to you, right? Is that something that you would entertain?
Yes, a lot of people do, actually. And I do review them, and it's not that they're in bad shape, but they're usually missing, key elements. So something that I always ask is, what happens if you, your husband, and the 2 kids are on a plane and the plane goes down? Where do you want your assets to go? That's usually one that people are like, wow, I never thought about that. No one ever asked me that. And sometimes the document has it, sometimes it doesn't. Sometimes the people click off, no, I don't need to even think about this. But once you have that conversation, like, oh, you're going on a family vacation, what happens if the plane goes down? It's very morbid and it's a hard question to ask, but little things like that is important to have the conversation.
I know in our firm, we run into a situation a handful of times every year with powers of attorney where someone says either they did it online or they went to an attorney who didn't do a particularly good job. And they said, if something happens to me, my spouse can, make my decisions in my absence or in my inability, and vice versa. Mm-hmm. What happens if that person can't do it? Who do we pick next? Not always does someone have a person in that number 2 position or maybe even number 3 position. We see sometimes that during a legal review of someone else's document or a client's document, which we get asked about, why do we review it when they already had it prepared by someone who presumably knew what they were doing? But we see this scenario all too often. You have let's say a single parent of adult children, and you have 2 children. You say, I'm going to name them both as my powers of attorney. But it doesn't go far enough. It doesn't specify, can they act independently of one another? Do they have to both agree unanimously? What happens if they don't?
Right.
Who has higher authority than the other? And I think a well-prepared document alleviates those questions.
Definitely.
We have those documents reviewed before they're needed, so that if they're ever needed, that's not the time to call into question anything that's in them, right?
Correct.
And I suspect with an online or, as you said, using ChatGPT or something like that, may not be the best way. It may be a good start, but it may not be the best solution, perhaps.
Definitely. And one other thing that a lot of people don't realize about the do-it-yourself wills would be that you need the original. So the original is essentially like gold at death. So you want to bring the original with the, notarized stamp. Make sure that, the ink, you can tell that it is, a wet signature. I sign all my documents in blue ink so that you can decipher whether it's a copy, whether it's the original. And a lot of people just, maybe they scan it and they toss the original. Well, that's going to be a problem once they pass away. But, maybe they didn't read the directions that were printed out from, the online source, and they didn't realize that the original was important to keep. So all conversations that I have with clients, and they say like, oh, wow, I didn't know that. So that's always helpful.
So I suspect that if somebody got this far in our episode today, they're 30 minutes in and they say, well, this is something I need to think about, maybe even do something about. And I guess that's the ultimate purpose of doing these podcasts. But if our listeners were to take one specific action item away from our conversation, Anna, what would you put out there as something that they can do the minute this episode ends?
I would definitely say organize your life. So even if you don't have the documents in place and, you're in a car accident on the way to the attorney's office to create these documents, I always say the easiest estate administrations on the death side are when you're organized during life. So even if that's one notebook that has all of your passwords, all of your assets, who your advisor is, who your accountant is, that is a huge stepping stone for whoever you're leaving. I would say that is number 1 on my list, and something that I recommend to all of my clients in the initial meeting is, how do you keep records? Where are the documents that are needed? Do your children even know where that document is or where that notebook is? Like, have these conversations, call your kid on the way home and tell them, I have this one notebook or this one document in my computer. Here's where you go. God forbid something happened. So
that's a good action step, and I think it's good advice for anyone, regardless of where they are in life, right?
Definitely.
If someone listening to this said, I like this person, Anna, she seems like a really nice person and a competent lawyer, how do I get in touch with her? What's sort of the best first step they could take?
Definitely. You could actually visit my website, www.acp-law.com. You can actually schedule a consultation right on there. I do free complimentary consultations, whether that be reviewing your documents or, creating a plan from scratch. The other option is to give me a call. It's 732-288-6162. And that's usually how we just, schedule a time to sit down, talk about your options. I would always like to say, everyone's situation is different, so we have to really sit down either face-to-face, on the phone, or virtually to be able to dive into what your needs are and what the best plan is for your exact situation.
Good. Well, I just want to thank you personally. I think this is an incredibly important topic. I think you brought it down to the level that is talk-aboutable.
Thank you. I try.
to coin a new phrase.
Thank you for having me. I appreciate it.
Thank you. And we thank you for listening to today's episode of Millstone River Live. If you think that it's been helpful and could be helpful for someone else, we encourage you to share it. Give us a like on the app that you're listening to, and check back again. New episodes coming soon. The information we discussed in this podcast is for informative purposes and should not be considered financial or legal advice. Besides your situation, laws vary by state. We invite you to contact us for guidance or consult appropriate financial and legal counselors based on your circumstances. We hope you've enjoyed this episode of Millstone River Live. Feel free to share it with someone you think might benefit. Millstone River Wealth Management is an independent wealth management firm based in New Jersey. We form a supportive partnership with our clients and help with financial education and planning. We welcome your feedback. Send comments or questions to podcast@millstone-river.com. More information about our firm can be found online at millstone-river.com. Thanks for listening.